Honourable member for Edmonton St. Albert.
Thank you very much, Mr. Speaker. It is indeed a pleasure to rise and speak to second reading of Bill C-461, an act to amend the Access to Information Act and the Privacy Act for public disclosure. Mr. Speaker, the bill's short title is the CBC and Public Service Disclosure and Transparency Act. This bill has two purposes. The first is to correct a recognized deficiency in the current Section 68.1 of the Access to Information Act, which currently reads, "This Act does not apply to any information that is under the control of the Canadian Broadcasting Corporation that relates to its journalistic, creative, or programming activities, other than information that relates to its general administration." Mr. Speaker, not surprisingly, the CBC took the position that it had an absolute exclusion with respect to its journalistic, creative, and programming activities, even so far as the Information Commissioner and her investigative powers were concerned. The Information Commissioner disagreed, stating that the Access Act allows her to examine any documents under request to determine if the exception applied. But as the CBC denied her certain documents, the federal court was called upon to make a determination. Both the federal court and the Federal Court of Appeal sided with the Information Commissioner. The appellate court referred to Section 68.1 as, quote, "not a model of clarity," because it created an exclusion and then an exception to that exclusion, which creates, in its words, a recipe for controversy. Meanwhile, the House of Commons Standing Committee on Access, Privacy, and Ethics held a study on Section 68.1 and recommended that it be amended to avoid any future such controversies. So, Mr. Speaker, Bill 461 attempts to provide clarity to the issue of CBC's access and disclosure obligations by replacing the aforementioned blanket exclusion with a discretionary exemption. It further adds an injury or prejudice test which must be satisfied in order for the exemption to apply, and reaffirms the Information Commissioner's absolute right to examine the documents in order to adjudicate disputes. Accordingly, the bill proposes that Section 68.1 of the Access Act be replaced with the following 18.2, and I quote, "The head of the Canadian Broadcasting Corporation may refuse to disclose any record requested under this Act if the disclosure could reasonably be expected to prejudice the corporation's journalistic, creative, or programming independence." Now, the word independence was deliberately chosen and replaces the current word activities, firstly because it is narrower, but more to the point, it is the independence of the public broadcaster which must be protected and therefore exempted from access requests, not all documents merely relating to its activities. Now, some will no doubt argue that this bill is an attack on CBC. Not so. I am a fan of much of what the CBC does. It's Tuesday night, and I rarely miss the Mercer Report or 22 Minutes, and I never miss Hockey Night in Canada, at least not when the Oilers are playing. And Power and Politics and Radio's the House are often on my TV and radio, respectively. This legislation, Mr. Speaker, is not about the CBC so much as it is about transparency and accountability. Section 68.1 of the Access to Information Act was flawed, and the Federal Court of Appeal said so. It was flawed, misunderstood, and litigated. This legislation attempts to remedy these defects. And some may suggest, Mr. Speaker, that this bill fails to properly recognize the unique position that a public broadcaster is in. Not so. I clearly appreciate and respect that a public broadcaster, especially as a journalistic entity, must enjoy a degree of independence from government. But, and this is important, the Information Commissioner is not part of government. The Information Commissioner is an officer of Parliament. And similar to our collective role in this chamber, the Information Commissioner plays an important role in holding the government to account. Moreover, the prejudice test, which is established under the proposed Section 18.2, recognizes this unique relationship between a public broadcaster and Parliament and government by providing a discretionary exemption when it is established that disclosure will result in prejudice to the CBC's independence. In any situation where disclosure would result in prejudice to the CBC, disclosure would be inappropriate. The prejudice test, I submit, Mr. Speaker, is a built-in protection not enjoyed by most government institutions, and this extra protection reflects an understanding of CBC's unique position as a public broadcaster. And some may argue, and I suspect will argue, that journalistic source protection is so sacrosanct that an absolute exclusion must be maintained. Not so. I agree that confidential journalistic sources must be protected, but dispute that an exclusion is either appropriate or practicable. Firstly, the Information Commissioner has unlimited power under Section 36(1) of the Access Act to compel production of, quote, such documents and things as the Information Commissioner deems requisite to the full investigation and consideration of the complaint. Mr. Speaker, I am simply skeptical that an exclusion can be drafted that can coexist with the Information Commissioner's unfettered powers to compel document production under Section 36. Moreover, and this is important, journalistic source privilege is not absolute. The Supreme Court of Canada has said so, and has said so as recently as 2010 in R versus National Post. It is not a class privilege. It is fact-specific and therefore must be examined on a case-by-case basis. Who is to determine, Mr. Speaker, if the four-pronged test developed by esteemed Professor Wigmore is satisfied if the CBC is granted an absolute exclusion? Well, the obvious answer is nobody. Is CBC to be made both judge and party in access to information requests? Certainly not. Disputes must be arbitrated by an independent watchdog, and the federal court has said, and I quote, disclosing records to the Commissioner does not amount to revealing them. Mr. Speaker, this bill contains parallel amendments to the Privacy Act to import the prejudice test when individuals request documents about themselves pursuant to Canada's privacy statute. But the CBC and Public Service Disclosure and Transparency Act makes a more substantive alteration to the Privacy Act. It moves the words range of before the word salary in the definition of exempt personal information for the highest wage earners in the federal public service. Currently, under Canada's privacy laws, only the range of salary can be disclosed pursuant to access requests, which I would submit is adequate for most income levels. But at the highest income levels, the increments become increasingly large as to become meaningless. For example, I have been advised that the current CEO of the CBC earns in the range of $363,800 to $428,000. Mr. Speaker, according to my math, that range of $64,200 is larger than many taxpayers' complete salaries, and arguably, therefore, is not meaningful disclosure. Accordingly, if Bill C-461 is adopted, the specific salaries and responsibilities of upper management, which this bill defines as DM1 and higher, will be subject to access to information requests. And this is important. This change would apply to the entire federal public service. CBC is in no way being singled out. And moreover, reimbursed expenses to all federal employees would also become subject to access requests. Now, Mr. Speaker, I have consulted widely during the drafting phase of this proposed legislation. I believe, and I believe Canadians believe, that they are entitled to meaningful access to how the Government of Canada spends dollars and how the government operates generally. However, Canadians, including federal employees, are also entitled to a reasonable expectation of privacy. Balancing these competing objectives is indeed a challenge and precarious. However, it is submitted that an injury-based test achieves that balance, at least as well as that balance can be achieved regarding CBC's disclosure obligations, as it requires a public interest analysis. The question becomes, is the public interest in disclosure greater than any consequential harm? And limiting specific salary disclosures to upper management recognizes the privacy rights of the rank-and-file public servants. Mr. Speaker, taxpayers rightfully are entitled to know how their tax dollars are being spent. In that regard, many provinces have established the so-called sunshine lists, which are publicly disclosed lists shining the sun on salaries, perks, and benefits paid to government executives, directives, and managers. Mr. Speaker, you may know that Ontario led the way with respect to such financial disclosure. The Ontario government introduced legislation in 1996 mandating the publication of names and salaries of all of its employees and officers who earn more than $100,000 per year. The purpose of the Ontario law is to provide a more open and accountable system of government. Disclosure allows taxpayers to compare the performance of an organization to the compensation given to its senior people running it. It allows taxpayers to know how their tax dollars are spent. British Columbia, Manitoba, Nova Scotia have all copied aspects of the Ontario legislation, with the reporting requirements varying and as low as employees earning $50,000 in the case of Manitoba. Now, my bill doesn't call for a website, but by mandating or at least allowing disclosure pursuant to access requests, the public will serve as a critical check on government expenditures and an effective deterrent to any government official tempted to treat taxpayers disrespectfully. This approach, I would submit, Mr. Speaker, is consistent with the purpose of the access legislation generally, as enumerated in the Act, that there is a right of access generally to records under the control of a government institution, and that necessary exceptions should be limited and should be specific, and that decisions of the disclosure on the government information should be reviewed independently of government. As an officer of Parliament, the Information Commissioner is independent of government and therefore in the best position to resolve the inevitable disputes regarding access to government information. Mr. Speaker, Canada has had access to information legislation in force since 1983. Canada was once a leader in providing access to government information and documents, but sadly, according to academics and according to the Information Commissioner, we are becoming laggards. Internationally, Canada is currently ranked 55th out of 93 countries in terms of our access and our openness. Moreover, Law and Democracy Institute says that the federal government is falling behind the provinces and ranking behind those provinces in terms of openness and transparency. As we have seen, Ontario is arguably leading the way with the most comprehensive Sunshine List. But British Columbia, Saskatchewan, Manitoba, Nova Scotia are all following suit and have implemented some variation of salary disclosure. But sadly, and this should be of a concern to this chamber, the federal jurisdiction is falling behind. Since its inception 30 years ago, there has been only marginal expansion of Canada's access laws. In December 2003, the then Prime Minister announced a new policy on the mandating of publication of travel and hospitality expenses for selected government officials. And in 2004, March 2004, the then government announced a new policy on the mandated publication on a website of contracts of over $10,000. But in my view, Mr. Speaker, sadly, very little has happened since then. Accordingly, the Information Commissioner, and I heard her on CBC radio, I was listening to her Sunday morning, the Information Commissioner observes a lack of commitment to openness and transparency at the federal level. Bill C-461, the Public Service Disclosure and Transparency Act, is an initiative by Parliament to remedy this trend. The spirit of this Act is based on the principle of disclosure. Non-disclosure must be the exception. Bill C-461 clearly promotes this principle. So, Mr. Speaker, the CBC and Public Service Disclosure and Transparency Act promotes open and transparent government and their role in holding government to account. Exclusions to government information prevents Canadians from holding their government to account. And I believe, Mr. Speaker, and I hope that all members believe, that holding government to account is fundamental to democracy. Although freedom to know is not a charter-protected right, freedom to know is inextricably linked to freedom of thought and expression and freedom of the press. Knowledge is power, and holding the government to account demands that knowledge and information be shared. Holding to account leads to the establishment of trust that there is proper stewardship over public resources. But opaqueness leads to mistrust. Accordingly, any attempt to weaken this bill and its attempt to increase access to information and transparency will be so regarded. As U.S. Supreme Court Judge Louis Brandeis said, sunlight is the best disinfectant. Mr. Speaker, Canadians deserve to have light shone on government information. Accordingly, I encourage all honourable members to support Bill C-461, the CBC and Public Service Disclosure and Transparency Act, without amendment. Thank you, Mr. Speaker.
Yeah.
Questions and comments? Questions et commentaires? Honorable Député de Longueuil-Pierre.
The Honourable Member for Longueuil-Pierre-Boucher. Thank you, Mr. Speaker. First of all, I must say that I'm thrilled with the quality of the words used, transparency, sunlight. The best remedy for anything is transparency and sunlight, but they can wrap themselves in the veil of transparency, but this bill is obsolete. It arrives at a time where the crisis no longer exists. Whereas this member said in 2011, well, I don't see why we need a public broadcaster in Canada. So to give a bouquet to Rick Mercer, my question is, why come up with this now when CBC just got an A, specifically from the Commissioner?
For Edmonton, St. Albert.
Well, I thank the member for the question, but he should read the Information Commissioner's report card a little more carefully. The A was with respect to timeliness, and timeliness only. She did not give CBC an A with respect to the breadth of their transparency or the breadth of what they disclose. It was only with respect to timeliness. Admittedly, CBC is quicker in their response time, but that is a much different category of disclosure than the breadth of disclosure.
Questions and comments? Questions et commentaires. The Honourable Member for Bonavista, Gander, Grand Falls, Windsor.
Thank you, sir. And I agree with the principle of transparency, and I appreciate where the member is coming from in a private member's bill to shine, put the sunshine on this. But I do have some very specific questions here because he talks about clarification. So the clarifying what was done by rule by the Federal Court of Appeal. What they said was the Information Commissioner, yes, that person embodies the decision to be made over whether their exemptions can be had. However, it would also, by introducing this injury test or prejudice test, by doing this, if the Information Commissioner feels it should be exempted, there are ways of going around this. So a person, like a wealthy corporation, could basically take them to court still. So they end up in court beyond what the Information Commissioner said. Am I reading this correctly? Or perhaps the Honourable Member can shed a little bit more light on this, because I think it's just what he's done here is that he has allowed many external factors to come into play and to bring the CBC into court time and time again to defend these three pillars when the Commissioner may have said, yes, they should be exempted.
Honourable Member for Edmonton, St. Albert.
Well, I thank the Honourable Member for his question. I mean, the Information Commissioner, as the member knows, appeared before the Ethics Committee and advocated on behalf of a prejudice test almost word for word as the legislation before this House contemplates. Now, he's quite right. There is no way to absolutely guarantee that a piece of litigation or that a piece of legislation is going to be judgment-proof or litigation-proof. But what I'm suggesting to him is, and thankfully we do have the courts that can review decisions of government if they feel that those decisions are wrong. But I would suggest to the member, if this is his concern, that if the prejudice test is properly applied by the Information Commissioner, although nothing prevents somebody from taking that to federal court, I'm suggesting that if the test is properly applied, the chances of having a decision overturned is very, very remote, if in fact probably non-existent.
Questions and comments? The Honourable Member for Wetaskiwin.
That's Wetaskiwin, Mr. Speaker, but that's a good try. It's a Cree word. It means the hills where peace were made. But I'd like to thank my honourable colleague for his efforts in this. I am on the Ethics, Access to Information, Privacy Committee, and I'm actually quite surprised by the line of questioning coming from across the way, because that committee actually reached a very much a consensus, nonpartisan recommendation, and there was only one major recommendation in the report, and that is that the committee called upon the government to amend Section 68.1 because of the lack of clarity from virtually everybody who testified before the committee on journalistic integrity and so on. We've heard. So I'm asking my colleague right now, and the recommendation is to study models from other countries and how they've got around this, and I'm asking him what's research or what presence in his proposed changes came from that research.
The Honourable Member for Edmonton St. Albert, you have about 30 seconds.
Well, thank you. The member will know, because he sat on the committee, that the Information Commissioner, when she appeared before that committee, referred to international models, specifically the United Kingdom and how they deal with disclosure pursuant to the British Broadcasting Corporation, and that's how she came up with the concept of the prejudice test, which I think will work quite well.
Reprise de débat, honorable député de Longueuil, Pierre.